Most people believe that if they don't create an estate plan, everything will simply pass to the people they love. That's not exactly how it works. Without a plan, you're unintentionally leaving some of the most important decisions of your life to the court. And the court does not know your family, doesn't know your values. It does not know what you would have wanted. There are 5 major decisions you're handing over, often without realizing it. And once the court steps in, your family has very little control. Today, I want to walk you through those 5 decisions so you can decide whether those are choices you're comfortable leaving in someone else's hands. Over the years, I've sat across the table from many families navigating the aftermath of a missing estate plan. And almost all of them believe the same thing. We thought we had more time. But estate planning is not really about death. It's about control while you're alive and clarity for the people you love. Decision number 1, who gets your assets? Most people assume if something happens to them, their spouse automatically inherits everything. That's one of the most common misconceptions I encounter. When you don't have an estate plan, your assets pass according to your state's intestacy laws. And that's a legal formula created that's applied to millions of people. But your family's not a formula. Let me give you an example. Imagine a married couple with children. Spouse dies unexpectedly with no will. Many surviving spouses are shocked to find that they may not inherit the full estate outright. A portion may be legally reserved for the kids. Now think about what that means in practical terms. The surviving spouse may need court approval to access certain assets at a time when they're already dealing with financial uncertainty and big-time life adjustments. In blended families, the income can become even more misconstrued. This isn't about the law being bad. The law is simply impersonal. Estate planning allows you to replace that rigid formula with direction given by you. What about who raises your children? If you have minor children, this decision carries enormous weight. If you haven't legally named guardians, you haven't actually made the decision. You've deferred it. And a judge, someone who has never met your family, will determine who raises your kids. Now, judges take this responsibility very seriously, but they're limited to the information presented to them, often by family members who may not even agree. Few decisions in life carry more importance than this one. Many loving parents leave it unaddressed because it's uncomfortable to think about. But naming a guardian is not about expecting the worst. It's about ensuring that no matter what happens, your children are raised by someone you trust and shares your values and parenting philosophy. This is not a decision most parents want to be left to chance. Decision 3, who will control the money? The third decision is one many families don't consider until it's too late. Who will manage the financial affairs you leave behind? Without an estate plan, the court appoints someone, typically called an administrator, to take that responsibility. And while that person is often well-intentioned, they may lack financial experience. They may not fully understand your family dynamics. They'll operate under court supervision, which can introduce delays and additional administrative layers. The issue's rarely bad intentions, okay? It's the absence of intentional deflection. Thoughtful planning allows you to choose someone capable and trustworthy rather than leaving that determination to a process that lacks personalization. Story that stayed with me is this. Several years ago, I met a family that had the sudden loss of the dad. He was organized in many areas of his life, successful financially, but estate planning was something he meant to do but never got to. After his passing, his wife found navigating the court process something that she never would have expected. Accounts were temporarily inaccessible. Decisions required court approval. Timelines stretched longer than anyone could have anticipated. Nothing catastrophic happened, but everything became harder than it needed to be. I remember her saying to me during one meeting, "I just wish we had handled this when things were calm." That conversation has stayed with me because it reflects what I see so often. These situations don't arise from neglect or from lack of love. They happen because no one ever talked the family through what's going to unfold if they pass. This is not about predicting tragedy. It's about removing unnecessary obstacles for the people you care about most. Decision 4. What happens if you become incapacitated? Many people believe estate planning begins at death, and that's not true. In reality, some of the most important planning addresses what happens if you're still here, but you're unable to act. If you were suddenly unable to make medical or financial decisions due to an illness or an injury or cognitive decline, who could step in immediately? Without the proper legal documents in place, family may need to petition the court to appoint someone to act on your behalf. The process is public, and it's time-consuming. It's expensive. It unfolds during an already stressful chapter of life. Some of the most carefully constructed plans I've seen were created by people who understand that protecting their family meant preparing not just for the end of life, but for life's unexpected turns. Incapacity is not rare. It's just unpredictable. Decision 5, how easy or difficult things will be for your loved ones. After many years in this field, I've noticed something nearly every family shares. Beneath all the technical questions is one quiet goal: make things as easy as possible for the people I love. A thoughtful plan is in place, families experience clarity. Responsibilities are defined, authority is clear, assets transfer more smoothly. When there is no plan, even close families can find themselves navigating uncertainty, paperwork, government involvement, court involvement, all while grieving. The court system simply was not designed to deal with your personal wishes. Only you can do that. So when we talk about estate planning, we're not really talking about documents. We're talking about maintaining control, protecting the people you love, ensuring your life's work passes according to your intentions, not according to a default statute. Let me offer you a simple exercise. Picture the people you care about most. Now, imagine them navigating the court, forms, and other major decisions without your guidance. Then imagine the alternative, a clear, intentional plan that quietly solves everything. That contrast is the power of planning. The good news is this: once a proper plan is in place, uncertainty is replaced with clarity. You regain control. Your family gains direction. And many people tell me they feel an immediate sense of relief because a responsibility they've been carrying in the background has finally been handled. Not when things slow down, not when I have a minute, it's handled. If this is something you've been meaning to address, the next step is a planning session with us where we help you evaluate the right structure for your family, your assets, and your goals. Because when it comes to protecting the people you love, hoping things work out is not a plan. Preparation is. I'm Mike Monteforte. Thanks.